Well, as you can imagine, very often questions arise on how a particular term in a contract is to be interpreted. If it's plain that there's just been a drafting error, that can obviously be fixed. But what if that's not the case? Now, traditionally, a court would look at a document, and if the terms of the document were clear, the court would enforce that, even if it appeared unreasonable. They wouldn't look at the background, and they wouldn't look at the circumstances, unless there was an ambiguity. Now, that's not the law anymore. The law was recently clarified in a Aberdeen case called Citywall Properties Scotland Limited against Pearl Insurance, and that went to the Court of Session in 2007. And in that case, Pearl Assurance rented from City Wall spaces for car parking, I think about 6 spaces. And the agreement contained a provision for the rent to be revised on a regular basis. Now, on a straight reading of that clause, the rent would have been dramatically increased each time it was renewed, out of all proportion of the actual cost of parking in Aberdeen. Now, although the effect of the clause seemed unreasonable, the wording was clear, and City Wall, who were getting the benefit of it, were absolutely clear that that was what was intended, and there was no ambiguity. But notwithstanding that, the court took the view that whether there's an ambiguity or not, a court should look at both the words of the contract and the surrounding circumstances at the same time.